Good day, everyone. My name is Scott Reich, and this is Crime Talk. This is the weekly recap of all the top stories throughout the week, conveniently located in one spot. Did I mention top stories from this past week in a recap? Don't tell me this is old news. Thanks for watching. We'll see you next time on Crime Talk. Lori Vallow and Chad Daybell. Lori Vallow has an alibi. That's right. Lori Vallow has filed a notice of alibi. It reads that the defendant, pursuant to the Idaho Criminal Rule 12.1 and the Idaho Code 19-519, provide notice of alibi as follows. 1. Lori Vallow was in her apartment in Rexburg, Idaho, when J.J. Vallow and Tylee Ryan died in the apartment of Alex Cox in Rexburg, Idaho. Defendant was with Melanie Give, David Warwick, and or Chad Daybell. Well, let's talk about that. So, just like we anticipated, the defense in the Lori Vallow Chad Daybell matters are going to be saying Alex Cox is the true murderer. And of course, he's not there to be able to defend himself. Why? Because he's dead. Yep, suddenly dead. Lots of dead people. Like I said, Lori Vallow is like the Black Widow. Everyone around her winds up dead. And I'm sure that's why Chad Daybell did not want to get out when he had the opportunity, because everybody winds up dead. I think he's safer on the inside. Now, the next motion is very, very interesting. The defense has filed a motion basically asking for Lori Vallow and Chad Daybell to be able to meet with their attorneys. And here's what I think is key, and this is why you have to actually read the motions. Apparently, there is a settlement being contemplated. Or is there a settlement being contemplated? Well, the motion says, come now, the attorneys for the defendant, and move this court for an order to allow the defendant and her attorneys to meet with the co-defendant and his attorney in a confidential joint settlement and strategy session. The motion says, hey, Lori Vallow and Chad Daybell were married in Hawaii on November 5th of 2019, and then on February 20th of 2020, Lori Vallow was arrested in Hawaii, extradited back to the state of Idaho, and she was able to talk to her husband by recorded jail calls from the date of her arrest to June 9th of 2020, when Chad Daybell was also arrested on this matter. The two have spoken by phone only one time since June 9th of 2020, and that was an arranged phone call on July 26th of 2020 between the parties and counsel. Call was approved by the prosecuting attorney and the sheriff and was not recorded. This is the interesting part. With settlement proposals, mediation, motion, and trial fast approaching, Lori and Chad would like to be able to talk together in person and on the phone about their options. The attorneys for the parties will attend any in-person meeting and phone conversations, but will not be recorded, and the conversations will not be used as evidence. The conversations can be deemed as settlement purposes pursuant to Rule 408, 410, and 507 of the Idaho Rules of Evidence, which means they can't be used against you later down the road. But what I think is interesting is that they would like to talk together in person to discuss some strategy and basically options. Is someone going to plead guilty? Do they want to testify? Are you going to testify for me? Are you going to hurt me? Those are the type of things that probably each side wants to hear in person from the other side before they decide what to do. Is Chad Daybell going to throw her under the bus? Maybe she'd like to hear it from him personally. Maybe she wants to testify for the prosecution and cut a deal. You just never know. I think it's very, very interesting that they're taking steps to do this. And at least the Lori Vallow's attorneys are acting like they're going to trial here in April. Now, another motion that was set was the estate's motion for sequestration. That's going to be a motion that's going to be heard next week. And it was filed back in September 29th of 2021. And like I said, so that's going to be heard on the 19th. And then there are several other motions that are going to be heard on the same date. Motion to prevent the death qualification of the jury, denied. Motion to declare the death penalty unconstitutional, denied. Motion to declare the Idaho capital punishment scheme unconstitutional, denied. Motion to declare the defendant not death eligible, filed January 4th of 2022, denied. Motion for the joint settlement and strategy session January 5th. I think the court is actually going to grant that because I think everybody wants to see if they're going to be able to resolve this case in one way or the other. Now, as you remember, Lori Vallow also filed a notice saying they're not going to run a mental health defense. Now, yes, Idaho does not have the not guilty by reason of insanity, where it's basically it's an affirmative defense. Yeah, I did it, but I was crazy. And then you go off to the state mental health institution for a very, very long time. But you can still use a mental health defense to say, I could not form the requisite intent. She says, I'm not going to do that. Probably because she's saying, I didn't kill anybody. Alex Cox did. Probably the reason for that, but the attorneys, you could tell by their filing, were really trying to cover their own butts for any post-conviction matters. It's going to get interesting. I know some people don't like that story, but listen, we got a trial date coming up, 2 dead children and a deceased spouse, allegedly, the result of a homicide. And it's just a really different case. But if you haven't watched it, I think it's worth watching. We've talked about it for a while. Like many Americans, we got a dog during the pandemic. My quarantine dog, Miss Winnie the Bulldog. Now, Miss Winnie has grown accustomed to being around us all the time. When we were leaving the house, Winnie would have extreme anxiety, so we decided to look for natural products to help with her anxiety. We looked for the highest quality CBD treats, and we were not satisfied, and neither was Winnie. So we created a high-quality CBD product that absorbs faster and provides the required results faster. Baked in Colorado, CBD treats and beverage enhancers are made with nanotechnology. The nanotechnology makes the CBD extraction more pure, also allows for Baked in Colorado products to work faster. Baked in Colorado products can help reduce your pet's anxiety, ease joint pain, and help with your dog's skin problems. Go to our online store and see what Baked in Colorado product is best for your dog. When you order at bakedincolorado.com, enter code WINNIE and receive 15% off your first order. We have a 30-day money-back guarantee. If your dog does not experience the desired results in 30 days, return the product and we will refund your money. No questions asked. All right, so there's some new video in the University of Idaho murder case that could support the investigators' theory that Bryan Kohberger, the suspect, actually returned to the crime scene in his white sedan shortly after he allegedly killed 4 students. That's right. Bryan Kohberger's phone allegedly pinged in the area of the student's Moscow home around 9 a.m. on November 13th, roughly 5 hours after he allegedly went into the house. That's a burglary with the intent to commit a crime therein, i.e. homicide, and stabbed the students to death. Now, that's according to the probable cause affidavit. That's their theory. Now, there's been some footage taken near the home in the afternoon on the following day showing a white car driving by. Now, Kohberger drove a white Hyundai Elantra, which became a key in the investigation in the search for a suspect. Now, the white Hyundai Elantra is believed to have been driving by the white Hyundai Elantra, believed to be driven by the Mr. Kohberger, and it was seen driving past the student's home at least 4 times on the morning of the homicides. That's right. They are estimated between 3:29 a.m. and 4:04 a.m. Now, the vehicle pattern matched the estimated time of the homicide, and it was later connected to Mr. Kohberger, who, as we all know, was a PhD student studying in nearby college there at Washington State University, Pullman. Well, the footage from the university showed a white Elantra leaving the campus in the direction of Moscow, Idaho, just before 3 a.m. on the night of the murders. The Elantra returned to campus around 5:25 a.m. the same morning. And near the homicide scene, there was video that was captured a white car passing by in the background as the journalists updated the public on the then developing case. The sighting came after police began investigating following the 911 call, which came in around noon. Now, the make and model of the car that's on the news footage is unclear, but it could possibly be Mr. Kohberger's car. We'll have to wait and see. Now, cell phone data allegedly previously put Kohberger in the area around 9 a.m. before the stabbings. were reported. The data also revealed an alarming trend showing the accused Mr. Kohberger killer had been in the area of the student's home at least a dozen times before the massacre, at very strange hours indeed. Now, all of these occasions, except for one, occurred in the late evening and early morning hours of their respective days. That's according to the affidavit. Now, lawyers for the family of Kaylee Gonsalves say that suspect Bryan Kohberger had no connection to any of the 4 students he is accused of murdering. And we're going to have to wait and see. But, we discussed yesterday, hey, everyone asked, Scott, how would you defend Mr. Kohberger? So I laid it out, what I would do. Had some demonstrative aids. In fact, I brought in the K-bar. You have to watch the video to see. And I brought in a sheath from a K-bar. And as you can see, there's the little snap on the top where somebody could certainly leave their DNA, and it could be easily recovered there, indeed. Well, go check it out. Since YouTube didn't want anybody to see it, let's try and get it there anyway. Is Bryan Kohberger. How many times have I said it here, ladies and gentlemen? It is always the defendant's own words that get them in the end, because they just can't keep their mouth shut. So many times clients come and say, hey, I didn't talk to the cops, except for that one little conversation to just see what was going on. And then you find out that that little conversation lasted for 45 minutes. And usually the client screws themselves. Any defense attorney will tell you, shut your mouth. Don't say a word, not anything, nothing, nada, zilch. Well, Mr. Bryan Kohberger apparently is, he's not the exception to the rule in any way. Apparently, he was talking to the police on his little flight back on the plane that took him from Pennsylvania to Idaho. And he reportedly told the cops, it's really sad what happened to those victims. Spontaneous statement, perhaps? Was it made during interrogation? He's clearly in custody. Did they elicit him? Sounds like a motion to suppress indeed. But we'll have to see. If it was a spontaneous statement, it's an admission by a party opponent and it comes in. Why would he feel sad about the victims? Unless he did something to them, right? Or maybe it's just an innocent comment and nothing to worry about. Anyway, the point is he couldn't keep his mouth shut. It's inevitable. Well, he apparently made this comment, as I said, as he's being extradited back to Idaho. And according to the police, he didn't speak directly about the student murders, but he did comment on their tragic fates. Apparently, he did say it's really sad what happened to them, but nothing more. He apparently was talking to himself during the trip as well. At one point, he was apparently saying something to the effect of, I'm fine. This is okay. Who knows? Maybe he doesn't like flying, perhaps. Or he's going back to face charges for homicides. Anyway, he apparently was quite reassuring of himself, saying that the whole thing wasn't awful. Take it for what it is. Take it for what the source says that Mr. Kohberger said. Now, obviously, for those who aren't familiar with this case, investigators have tied Mr. Kohberger to the killing through his cell phone data, car make and model, and DNA found on a knife sheath allegedly left at the scene. Now, officials have not found any connections between Kohberger and the alleged victims or a particular motive. Not that they need one. Most everybody would like to know why. Why? Anyway, the phone data revealed that he allegedly had been in the area of the student's home in Moscow, Idaho, at least a dozen times before they were killed in their beds. His phone pinged in the area at odd hours, all but one of the 12 times in the late evening or early morning hours. We'll continue to follow that definitely, and he does have that setting that's scheduled for tomorrow. It was a preliminary hearing demand. As we told you the other day, it was a date to get a date, and that's exactly what took place. The whole hearing, which we put up so you can watch it in its entirety, lasts roughly 5 minutes. Mr. Kohberger was entitled to have a preliminary hearing within 14 days of the advisement of the charges. Obviously, his attorneys need more time to do that, and had he requested that hearing within 14 days, the court would have obliged him, as well as the prosecution. He waived his right to a hearing for a preliminary hearing within 14 days, which is his right to do, and he could have said no. He's listening to his attorneys that say, hey, this is an important case. Obviously, we have 4 deceased individuals, and we need to make sure we do our investigation, and we need time to do it correctly. So, since there's no rush on this case, guess what? The court, the district attorney, and the defense counsel for Mr. Kohberger agreed to a hearing date in June 26th. Now, I expect a little bit of a continuance, but I thought maybe 2 months. 5 months now? Really? Wow. Anyway, I hope they're ready, and I hope it's going to be televised so that we can see what evidence exists. Of June 26th, put on your calendars, a 5-day preliminary hearing. Now, Mr. Kohberger was sporting a new look there in court, and it looks like he, has some scratches on his face. There's been multiple reports, but let's face it. Do we really think he cut himself shaving? Now remember, ladies and gentlemen, when you're in custody, yes, they let you shave, but normally the sheriffs literally check in and check out the razor blade. And yes, it's not going to be the sharpest thing because they don't want it to turn into contraband where it is used to harm somebody else, or Mr. Kohberger could potentially harm himself. So they keep, pretty close eye on all the sharp objects. I don't know. What was he shaving himself with? I mean, we've all nicked ourselves shaving before, but never that big. What was he doing? Shaving with a K-bar? I don't know. Maybe he's not getting along well with others, and maybe, somebody made that abrasion on his face when they were rubbing it into the ground. Maybe somebody hit him. I don't know. Let me know what you think may have happened. I know we don't usually like to speculate, but hey, when they're going to make us wait another 5 months for a preliminary hearing, what else are we going to do, I guess? Just kidding. We like to keep it. But if you know what really happened, let us know. Next, Lori Vallow and Chad Daybell. Remember, we talked last week that the attorneys for Lori Vallow were requesting a conference with Chad Daybell and his attorneys in person so that they could discuss, which stated sounds like maybe there's an offer on the case, or at least be able to get together to talk about a defense strategy. And apparently Lori and Chad haven't had much time to talk since, they've been arrested and all that stuff. And she's gone off to the state mental hospital. And, well, they need a little time to talk. Now, I get what the defense is trying to do. Clearly, there's something going on. They need to talk before they decide how they're going to proceed. It could be an offer. It could be a plea of guilty. You just never know. But how did the state respond? Well, the short answer is hell no. Is it worth listing the rest of the reasons? Absolutely. So the state sponsor says the state has serious reservations about allowing the co-defendants to have face-to-face or other communication directly with each other. While the state recognizes that the defendants may communicate through their counsel and also may strategize together through their attorneys, which the state would not be a party to or have input on, there is no inherent right to or privilege for the defendants to have direct communication. The state recognizes the defendants have agreed to not use any evidence or information they may obtain through any discussions or meeting against each other. Nevertheless, the state is not willing to make a similar agreement. Any communication between each individual defendant and his or her attorney are confidential. However, having the other defendant and or his or her counsel present would make them potential witnesses of statements made by the other defendant and eliminate any claim to attorney-client privilege. In addition, the defendant is arguing that there is privilege pursuant to the Idaho Rules of Evidence 408, 410, and 507. This is simply not the case. Idaho Rules of Evidence 408 deals with statements made during settlement or mediation negotiations, but without the state present, there can be no true settlement or mediation. Regarding Idaho Rules of Evidence 410, since there is no plea being entered and no attorney for the prosecution proposed to be present for the discussion, this rule is not applicable. Idaho Rule 507 is applicable to mediations, but the rule doesn't necessarily protect statements made by co-defendants, especially to each other. In addition, the defendant is requesting to have a settlement conference separate from any mediation. One further concern for the state is how a meeting would be facilitated, which would protect the confidential privilege the defendant is claiming and also meet the safety concerns of the parties, especially given the nature of the charges pending against them. Wherefore, the state respectfully requests that the court consider the concerns raised by the state. That was filed January 12th, which was yesterday. So here in this particular situation, the defense parties want to get together and talk. I would take issue with some of the prosecution's concerns. Listen, if this is going to get the case resolved or they need to meet, this could be a defining moment in the case. Either A, they're going to jump on board altogether, or maybe one's going to sacrifice themselves for the other. You just never know. I get their concerns. The prosecution wants to control the situation. The defense probably wants to have some resolution one way or the other. You eliminate this by you putting them together. They understand that anything they say can be basically used against them, but you eliminate the need for having the attorneys being witnesses against each other by having an investigator from each side present, taking copious notes as to what was said. Problem eliminated. Remember, prosecutors interview victims all the time. Prosecutors don't become witnesses in that particular situation. Why, you may ask? Because they have an investigator take notes. Otherwise, every time a victim spoke to the prosecutor, they would be made a witness. So I think the prosecution is objecting to object in this particular situation. If they need to meet, I get they don't have a right to. But if this is going to provide some solution or resolution to this case, then let it happen. Let it happen. Versus just saying, hell no.